Good afternoon, or probably good morning, depending on where you all are logging in from. But we want to thank everybody for registering for this webinar. We're very excited about it. We've got a good panel here for you today. Going to give it about 30 more seconds because let's face it, we're not everybody is on time. So we'll give it 30 more seconds and then we will start. This is the first annual Hearings in Review sponsored by Bressler, Amory & Ross, which is the law firm that I work with, and Sean Coughlin, who's also on the panel, works with. What we're going to do today is we're going to look back on 2020, which has been a remarkable year for really so many different reasons, but especially for legal practitioners and the people who are the administrators of our forms of justice around this country, not only arbitration, but state and federal courts. And this year has really been the year of what we call virtual trials or virtual hearings. And you'll hear me refer to Zoom from time to time, primarily because that is one of the most popular, if not the most popular, services that is used around the country. It's used by FINRA, which is one of the main forums that I know many of you practice in and are familiar with. There's been some exciting developments, and I think the developments have actually raised a lot of questions that really go to the heart about what it means to practice law, to represent both public investors, to represent plaintiffs, to represent defendants, and what is the best way to achieve that representation so that the facts come out and a fair and impartial decision can be reached. Now, we've got a PowerPoint today. I'm going to use it sparingly, primarily because I think you'll find that the panelists here today really use PowerPoint sparingly when they are practicing law, or with Rick when they are making presentations, because we want you focused on what we're saying. We hope you find that interesting, but we will use a PowerPoint from time to time just to drive home some key points and maybe leave you with some indelible images that will help you remember some of the things we talked about today. At the end of the presentation, we'll make that PowerPoint available because it does have a series of slides that have sort of a checklist of things that you should be thinking about if you find yourself needing to participate or conduct a virtual hearing. Now, if you forget the details or the anecdotes or the interesting comments today, I want you to take away at least 3 large points here today. And number one is, I believe, and the panelists here today believe, that Zoom is here to stay. In what capacity, I think, is still to be determined. But I think the overall message that you're going to hear today is Zoom will be an increasing part of not only cases in court, but also arbitrations. Second takeaway is the medium is the message. And what I mean by that, that's an old term from the 60s, really used in connection with what was then new television and its impact on the American public. But what do I mean by the medium is the message? What I mean is that Zoom is critically different from an in-person hearing. The medium will subtly shape the reception of the content. And, what is the content in a legal proceeding? Well, it's primarily testimony from witnesses, and it's primarily the review and examination of documents. And we're going to show you here today that that is going to be impacted significantly by Zoom in ways that you may anticipate and in ways that you may never have thought of. Number 3, you're going to have to, as a practitioner, adjust your preparation and techniques for this new medium, because we're going to show you that there are limitations, but there's also flexibility with this new medium, but you have to know what they are. Now, what you're not going to hear today is a complete list of best practices. And that's because we're really too early in the process. You will hear some best practices. But what we're really trying to do is, number one, identify the root difference between a virtual hearing and a hearing that's in person. And once you have that in mind, we're going to identify some broad challenges that you will face so that you can prepare accordingly and conduct yourselves during these proceedings accordingly. And you may find too that many of these thoughts and ideas that we have apply also to in-person hearings, but what I think you'll find is that they apply even more so in the virtual settings. Now, it's important for us as attorneys to adopt to this because, you know, while the whole world is really adopting to working remotely, distance learning, and, you know, the same things we're having to do as attorneys by Zoom, I think we all know that, you know, being an attorney compared to other professions is probably the most hidebound of all professions because we use terms like hidebound. And I know lawyers that still refer to an exemplary attorney as Clarence Darrow, or, you know, still use Courier font. So we're sort of the last to catch up with technology when it comes to being an attorney and in the legal world. I'll also note Perry Mason went off the air in 1966, so it's probably time we dropped the Perry Mason reference as well. So I've told you what our three takeaways are, and like we all learned in law school, it's best to show, not tell. And so let's get on with the show. So our first guest today is Rick Berry, the man that needs no introduction. Rick is the ever confident, smiling face that runs FINRA Dispute Resolution. Rick is the executive vice president and director of FINRA Dispute Resolution Services. And Rick has been there a long time. He was with the NASD, which was the predecessor organization that was renamed FINRA in the mid-2000s. He's been there since 1995. He's seen a lot of changes over the years, so he's going to have a great perspective to share with us today. And so welcome, Rick. Why don't you tell, I think a lot of the practitioners, at least in the arbitration space, are aware of what FINRA has made available in terms of the Zoom platform. Why don't you tell our audience how FINRA actually got started with Zoom and how that evolved?
Thanks, Brad. You know, it all started, as you all know, in mid-March of last year when we administratively postponed all of our hearings. At that time, we had no idea that we'd be talking about additional administrative postponements a year later, but here we are. So right now we postpone hearings through June 4th. And just a tip in terms of when we decide this, we have a clear pattern. At the beginning of each month, we look at the data. And as you know, health and safety is primary importance to us. We look at the data and we announce what's going to affect 2 months later. So we just announced at the beginning of March that we are postponing May through June 4th hearing dates. So you can count on us making an announcement at the beginning of the next month. But we're eager to get back to in-person hearings. We really would love to be back to in-person hearings, but the data is just not there yet for health and safety. But we are allowing parties, if they agree, to go forward with an in-person hearing as long as all the arbitrators agree as well. We've had one case in Houston go forward in late January with an award that came out in early February. And we have an additional hearing set for May and one for June, and an in-person mediation set for April.
So if all the parties agree and the arbitrators agree, then FINRA will allow the proceeding to go forward in person, right?
That's right. The only thing we ask, Brad, is that they meet local and state COVID orders.
Sure. Now, was FINRA using the Zoom platform before COVID hit in March of 2020?
Yeah, we were particularly lucky in that FINRA had been using Zoom for over 2 years. And FINRA is incredibly concerned about safety and security, especially of a platform, any external platform. So our security computer experts tested some more Zoom, and we've been using it for our meetings for 2 years. So we were very familiar with it. We trust it. We know it has great security features. And just to note that we also were very lucky in that our staff was already working from home 2 days a week. We had already turned our files all electronic. And of course, we have the portal, which is our system that the parties and arbitrators provide. They get documents from us and they turn documents into us through this portal. So we're paper free.
And when you rolled out Zoom in March of 2020 for the arbitrators and for the practitioners in this area, give us some statistics looking back on 2020 about how Zoom was utilized.
So let me start off, Brad, by saying that we made it clear right at the beginning that we will do Zoom hearings if all parties agree or by panel order. And there was a case that came down called Legaspi that reinforced the fact that our panelists do have the right or are authorized to declare that virtual hearings are the way the case is going to proceed. So to answer your stats question, since the initial postponement of in-person hearings to today, we had 206 cases have conducted at least one virtual hearing. 82 of those are customer cases. We've had 84 awards, and 46 of those are customer awards. And in terms of joint motions, there were 213 joint motions. And in terms of contested motions, we had 318 contested motions. And we're seeing around a 70% grant rate on those.
So working backwards a little bit, I think you mentioned a number in the 300s. That was the number of cases where both parties consented to use Zoom?
Yeah, so the joint motions were 213 of those, and we had 318 contested.
Okay, so 213 where the parties agreed, 300 plus where it was contested. And of those 300 plus, about a 70% rate in favor of proceeding by Zoom.
Exactly.
Okay. And you mentioned that there were 84 customer awards. And before that, repeat that statistic about how many actually proceeded to at least one day of a final hearing.
Yeah, so we have had 206 cases that have conducted at least one virtual hearing.
Now, does that include dispositive motions like eligibility motions or the like?
So that number does not include those. These would be true on the merits in Zoom hearings. Okay.
Now, there is at least one study that I've seen circulating that posits the notion that perhaps public investors are not faring as well by proceeding virtually. Do you have any viewpoint on that to respond to?
You know, absolutely, Brad. One of the things that's really hard for anyone looking at our data to know is that we have a very conservative way of calculating the quote unquote win rate. And that number does include those dismissals with and without prejudice as customer losses. So for example, if you have a 12206 6-year eligibility motion that's granted, that's counted as a customer loss. If you have a 12504, one of the 3 grounds under that for dispositive motions, or if the case is thrown out as a sanction, all of those are counted as customer losses. If you take those out of the mix and then compare in-person versus Zoom, the data is much better. And so let me just explain why the dispositive motions played a role. And the person who did the study, you know, I don't think they took that into account. And imagine that you have this flood of cases normally of in-person hearings happening and a trickle of these dispositive motions. Then you cut off the the flood of in-person hearings, and you have a smattering of Zoom hearings. Meanwhile, those dismissal motions, which are not done in person, are getting decided. And it's taking up a huge portion of those cases by award are taking up a huge portion of the customer loss. So if you take those dismissals out, we find that the 2020 in-person win rate was 50%, and it was 40% for those held by Zoom. For those cases decided in January 2021, we had 100% win rate for Zoom. And in February 2021, 45% win rate for Zoom. So if you're comparing apples to apples, Zoom and in person are pretty comparable.
Okay. Now, I think what everybody wants to know is, I know I'd like to know, is we heard President Biden announce that by May 31st, that at least the United States would have in hand vaccines to cover the entire U.S. population. Now, we know there will be periods after that where the vaccines have to be administered. But at some point, I know we're all hoping and, really praying for a return to normalcy, whatever that may look like. Now, when we get there, which way is the wind blowing at FINRA in terms of the Zoom platform? Is FINRA looking to expand its use as part of the arbitration process? Are they remaining neutral? What is FINRA's sort of viewpoint?
So Brad, I think we sort of laid our cards on the table when instead of putting our Zoom statistics on the COVID page, we put it on our stats page. And that's because we think Zoom is here to stay. It certainly won't be ubiquitous as it is today, but we're gonna see smaller cases. The parties agree to Zoom. We're going to propose that we use video conferencing for those special proceeding cases, those smaller dollar cases. We're going to also continue to train our arbitrators and get them ready for this. And finally, I can see a world where right now, Peter may have flown in a witness for 30 minutes of testimony. He's not going to do that going forward. He's going to say, you know what, if this witness isn't that important and it's only 30 minutes long, we'll just have him Zoom in. So you'll see a lot of hybrid cases. So we think Zoom is here to stay, and we're going to make sure we keep improving the process so that when you do want to use Zoom, we do it well.
Thanks, Rick. And now I want to ask a question of Peter Mougey. Peter, good morning. How are you?
Good morning. Thanks for having me.
Peter, for those of you who don't know or have had the pleasure of litigating with Peter, Peter is the chair of the Levin Papantonio firm's Securities and Business Litigation Department. Peter has been recognized as one of the state of Florida's top 100 trial attorneys. Peter has tried almost 50 cases to a verdict or an award, either in state or federal court, or in FINRA arbitration, or in some other commercial arbitration forum. He is currently the co-lead of the distributor case of the National Prescription Opiates litigation, which is a sprawling, massive, complicated piece of litigation involving opiates, which we've all seen in the news. And Peter is also the past president of PIABA, which is one of the bar associations comprised of attorneys who primarily represent public investors in their claims against financial institutions. Peter's experienced, like everybody else on this panel. I think it's important to hear what he has to say, and that's why he's on this panel. So Peter, sort of picking up where Rick left off, from the public investors' point of view and an attorney representing public investors, what's your overall thoughts about Zoom? Do you like it? Would you like to use more of it? Do you not like it, or is the jury still out?
I think the jury's still out. I mean, I don't think. I hope if I were ever just given the choice, maybe a year or two down the road, that I think almost all of the time I'll still pick an in-person trial or argument or arbitration. But I do believe, as Rick suggested, that Zoom and the video trials, arguments, depositions are here to stay. And I think there's some important tools that we can pick up from Zoom and use and incorporate into our day-to-day practice. I've learned a lot over the last year, made some mistakes, still learning, but I think the jury's out on how much, but I definitely agree with Rick that it's here to stay.
And we'll talk about in just a few minutes with the entire panel what we like about Zoom, what we don't like, and what are the obstacles that are going to have to be overcome by practitioners in this area. Let me go to Richard Szuch. Rich, good morning. How are you?
Wonderful. How about you?
I'm good. And for those of you in the audience, and thanks, by the way, for everybody who registered for this. I just want to note we have over 400 people who have registered for this webinar, and we really appreciate that. And we hope that we give you a good product here today. If you have questions, because of the sheer number of people who are participating today, if you could use the Q&A function on Zoom, you'll see it's at the bottom of the screen, and submit your questions. And what we'll try to do is at the end of the webinar, we will try to go through those and answer a few. And then for those that we don't answer, we will certainly, after the webinar is over, find a mechanism and a time to address those questions. So thank you for registering, and thank you for your questions. Let me tell you about Richard Szuch and why you should want to know what he has to say. Rich is currently the Enforcement and Investigations Chief for the New Jersey Bureau of Securities. So he is an active cop on the beat now. Rich has recently served as the lead interrogator in a $1.8 billion securities fraud case involving a company called GPB Capital Holdings, which itself is a large investigation involving the SEC, the United States Attorney for the Eastern District of New York, and 8 other state securities regulators. Rich is a former partner of mine here at Bressler Amory. He practiced law here for many years. He started his career as a prosecutor, and he actually tried more than 40 criminal cases to a verdict before the age of 30. And he, just as importantly, Rich has been the lead lawyer in more than 70 FINRA arbitrations that have gone to an award. So lots of experience here, both as a general litigator, both as a practitioner in the space of securities litigation, and now as a regulator. So Rich, why don't you give us a feel for what's happening at the state regulatory level, specifically New Jersey, or what you're seeing from your compatriots in other states as they try to continue their function of regulating the securities markets and its participants in this time of COVID.
Sure, Brad. First, thanks to Bressler for having me and putting this panel on. It's a pleasure to be here. I am obliged to say that my views expressed here are my own, and I am not meaning to represent the views of our Attorney General or necessarily the Bureau of Securities, but you'll be able to hear what I think about things. I'd also like to thank Sarah Gill at FINRA, who helped bring the smiling face to the panel, and Rick Berry. She's a senior director and government liaison at FINRA and a good egg. I wanted to give you just like a real treetop view on what's going on with state regulation. We don't have the data for 2020 yet. It's in the process of being gathered. It'll be available in the fall, but I did talk to my colleagues around the country preparing for this to give you a sense of the world and how 2020 is likely to compare with 2019. To give you the most recent data, I mean, if you look at a 5-year view of state regulation across the country, there are 67 jurisdictions under the NASA umbrella. New Jersey is one of those 67 jurisdictions operating under the North American Securities Administrators Association. Countrywide or NASA-wide, the number of enforcement investigations has trended up significantly over the past 5 years, and in particular in the last 2. Interestingly, though, the number of actual enforcement actions has remained relatively stable, although the numbers are increasing. So for example, 19 over 18, there was a 23% increase in the number of investigations, 19 over 18. Total number of investigations was 6,300. And in terms of the actions, 19 over 18, they were up 38% over the year before. And there were 2,700 enforcement actions brought. The total amount of restitution obtained through these enforcement actions was around $700 million. You know, the data that I'm getting anecdotally, just talking to my friends around the country, is that people are either at or above where they were in 19, even with the dislocation of the markets, the world, regulation, everything around it. So there definitely was a period of time where regulators, consciously, I think, and properly so, were taking a pause to allow people to adjust. I think what regulators quickly learned was that, happily so, by the way, financial services firms were really well suited, frankly, much like law firms are really well suited to dealing with a virtual environment. So, we laid off on subpoenas, OTR requests, just generally laid off in the period, I'll say April through May. And then, June, it was basically back to business. That GPB case you mentioned was prosecuted, the investigation was prosecuted entirely remotely, 10 million documents, 8 states, the SEC, DOJ, incredibly complicated fact pattern, entirely remotely. Nobody met in person for anything. So, to me, if we can do the GPB case remotely, we can do anything remotely.
Has there been any, Rich, let me interrupt real quick. Has there been any limitations that you've seen as a regulator using the Zoom platform, or has it all been to the positive?
So, there's 2 pieces to my life at the Bureau. I'm in the investigative phase. My law job right now is not a law job, which I actually don't mind so much after 30 years of practicing law. I hand the ball off to the lawyers that support the Bureau, and they deal with the in-court or administrative hearings that get prosecuted as a result of the investigations. Similar arrangements exist around the country. Sometimes the lawyers and the investigators are the same people or work in the same office. Ours happens to be split. So from a regulatory perspective, I like the medium. I see people fine. To me, all the things I need to see can be seen in their face. I don't need to see them jiggling their feet. I'm figuring they're doing that. And I like, actually, I kind of like the distance. I don't need to be in the room with the people. And I like the distance because for the same reason trial lawyers probably don't like it, I like it because it takes out of the room some of the emotion that to me could get in the way of an efficient examination.
And let's talk about that. You say that the distance takes out the emotion, and that's a central concept of what we're going to talk about today is distance and emotion, and what I like to call the human element. And when we talk about the medium being the message, we talk about well, what does that really mean? That's a catchy phrase, Brad, but what are we really talking about here? Hang on here.
While you're doing that, I don't know if I put the period at the end of the sentence, but nationwide enforcement is at or above where it was this time last year. COVID has certainly been disruptive in everybody's lives, but regulators, as far as I can tell, have been able to make an adjustment like everybody else has had to do. And the numbers other than that, I'll say respite provided for nearly a fiscal quarter when this all happened, we're at full steam ahead. The other thing I'd point out is, I don't know if anybody thought about the date, but today is March 9th, and it's exactly 12 years from when the market bottomed out after the famous bear market 2007 to 2009. As regulators, we're always worried about markets that reach the heights that this one has. I just haven't talked to any really smart people that told me that you have the kind of irrational exuberance around the market that makes regulators worry that something's going to get crossed up quickly. Obviously, we're always looking at product failures and fraudulent sales practices, but this market is an incredible market. It's run 12 years up, and according to what the economists are saying, top to bottom, side to side, the economy should expect growth this year and next. And so that, to me, it's a blessing, but it's a curse, because people may not be as careful as they should be because they don't appreciate, because they've never been in the middle of it, that things can go bad as well in investing.
Well, and we also have the federal government, unlike in past times of crises, for the first time has made it clear they will use unlimited resources to prevent a market calamity, a liquidity event. And a lot of the experts I have talked to and listened to their prognostications are keeping their eye on that ball. How much longer is the Federal Reserve going to basically backstop this market? And we should do a webinar on that. Before I go to Sean, let me hit one of the main themes here of our presentation, and it's the human element. And I know in the beginning, when I was preparing for my first Zoom arbitration, it was really easy for me to just really visualize it as, well, this is just like an in-person arbitration, but we're going to do it by video. I think many of the practitioners in this space, I know Peter and I had a case a couple of years ago in Atlanta where we had at least 2 or 3 witnesses that appeared by video conference, and everything went smoothly. It went well, but this is really significantly different, because unlike having everybody in the room while one witness is remote, everybody is remote. And the only persons you are with are the people on your team. You're not with the fact finders, whether that be a judge or a jury or an arbitration panel. You're not exposed to the other side's witnesses. All of that is taken out of it. You're really communicating on a screen. And what this picture I have here represents is the perfect example of a message where the medium is everything. The message here is simple: will you marry me? That's a message that can be conveyed by letter. It can be conveyed by text. It can be conveyed over the phone. But if you want a yes answer, you probably better get down on one knee and do it this way, because the medium, the way the message is conveyed, is everything. Now, this is an extreme example, but I use this as a lens through which we can think about what really goes on when you are having an in-person hearing. And just think about it. You have people who have generally traveled from distances from far to very far, all in one courtroom or one hearing room. You all have each other's attention, because many of these cases involve, one party who lost money, or, a business deal gone bad. They're often fraught with human emotion. And I think all of us practitioners can feel that when we walk into a hearing room or into a courtroom, that human element. You also have things like, with arbitration panels, you have all those moments in between where you're not on the record. You have your morning pleasantries. You have your meetings at the hotel coffee station. In the courtroom, you're sort of chatting around with other lawyers and maybe the clerk, maybe the court reporter, and you have all of these chances for these small human interactions that really matter, and they really build some sort of human cohesion about the process that is going on. And when you do this remotely, you lose that. You lose the ability for the arbitrators to step out and have lunch together uninterrupted, where, you know, presumably they often would discuss, you know, what's going on in the case, what evidence they've heard. So when you remove the human element, you go a long way to really subtly changing the process. So Sean, let me go to you on this. And for the members of our audience, let me tell you who Sean is. What's that?
I said, I hope I can bring a human element.
Sean is a partner of mine here at Bressler Amory. Sean, just like Rich, started out in the Brooklyn District Attorney's Office. He tried 44 cases to verdict. From there in 1994, he went to what was then Smith Barney, ended up holding several senior positions in the legal department. He joined Bressler Amory in 2011 as a partner. And during that period of time, both at Smith Barney and at Bressler, Sean has litigated state, federal court cases, and he's also tried, and I double checked this to make sure it was accurate, Sean has tried more than 100 FINRA arbitrations, including a $0 award in a gigantic auction rate securities cases alleging $120 million in damages. So Sean, you've been at this, you know, since 1994, at least in this space. So what are your thoughts about this loss of the human element and how that affects the process?
You know, from the very beginning, back when I was in Brooklyn, I always thought we were producers, directors, and actors in these proceedings. And I think now that we're on a TV screen, we're even more so. Excuse me, I'm actually going to turn myself off so that I don't look at myself. And I think that's an important thing when we're doing these types of presentations, because too often we wind up looking at ourselves and become distracting to ourselves about what we're doing. I think that the biggest problem that we have in putting together hearings for arbitrators, for judges, for juries, is how we're presenting our witnesses. We all get very caught up in the presentation that we're doing because lawyers like that. But we need to remember the real important person in the room is whatever witness is on the stand. And it's how you go about putting that person in a situation so they can put their message across to the trier of fact. And that, I think, is our number one hurdle in putting these cases together. Working with exhibits, working with the witness, and trying to put it in a way that the trier of fact can get your message.
And so what are the particular problems though, Sean? We always want our witnesses, whether they be in person or through a video screen, to be prepared, to understand the nature of what they're going to be asked, and to, you know, convey the truth in as clear and concise a way as possible. What's the extra hurdle though with Zoom?
So let's just start talking about that. And I think I know Peter and I have talked about this in some of the prep sessions. A lot of it is just dealing with technology to begin with. A lot of times, witnesses in these proceedings are older. They might not have the best technology to begin with. They're sitting at home, they've got a fan in the back, there's something distracting there. Nobody's thought those issues through. And so the trier of fact gets distracted by other things. You got that. Are they able to, like you were showing before, certain things from our PowerPoint presentation, can that witness turn around and manipulate that in a manner and so they can show the triers of fact what we're looking for? And if you don't practice those things from the very beginning, you're never going to get these people up to speed. You can't turn around and show up, a week before with, your number one witness and get that individual ready if they've never been on a Zoom call and had to do a serious presentation before. So that's your primary thing.
Yeah.
I think secondary, it's how are your triers of fact going to handle the exhibits? Are you going to be putting them up on a screen, or have you worked out, like if I called up Peter Mougey and said, hey, we've got this case together, what are we going to do to present the evidence? And Peter, what are your thoughts on presenting evidence?
Well, I think when we first started this whole process with Zoom, I automatically assumed and didn't really creatively think outside the box of Zoom calls. We're all sitting just like we are today. We're all sitting on a kind of a conference room type environment. And it really never dawned on me that we can take more advantage of of some of the three-dimensional components we have in person. Different camera angles. I love to use flip charts. I love to walk around. I like to use the room. And I kind of just threw all that out the window and sat in front of a camera and a couple of my partners and I just tried a case and sat there for 2.5 weeks, just like we were on a regular Zoom conference call. I think it was a big mistake. And in this opportunity to talk with everybody about what we've learned, pluses and minuses, I think we should not assume that that these are Zoom conference calls, and we ought to shift the paradigm and look at other ways to do things. So presenting the evidence to me is go ahead and take advantage of Elmo if you use it. Go ahead and take advantage of flip charts and walking the room and demonstratives. Use some different camera angles and use more of a live environment rather than just sitting at the end of a conference room table.
I agree. I think you almost need to turn around and have a video camera on you as the presenter of the evidence when you're questioning your witnesses, so the arbitrators can see you the way they would have seen you in a hearing room. And at the same time, you need to have a similar type of camera set on your witness, so the witness gets a response, and it almost looks like the witness is talking back to you and to the arbitrators as to just looking at a conference room.
Let's talk about that, guys. Let's talk about what we do, what we're taught to do as good trial advocates, and that's command the room. And this is just a scene from a movie I think many of us are familiar with, A Few Good Men, and it's just a good cinematic depiction of what a good trial lawyer does, the things that Peter and Sean talked about, commanding the room. And what does that really mean? Well, it means, like Peter said, it's using the three-dimensionality of the room to not only convey your facts and points best, but to keep the attention of the fact finder. This movie was a great example. If you recall, Tom Cruise doesn't just sit at counsel's table and ask questions. Sometimes he starts there, he stands up, he walks toward the witness. How many times have you been in an arbitration where you look directly at the arbitrators, but you're asking a question to the witness because you're signaling to the panel, hey, this is important? How many times do you look at the jury when you ask a question of the witness because you're signaling to them, I think this is going to be interesting, you should pay attention? Multimedia exhibits, flip charts, blow-ups, writing things, all of those are tried and true trial techniques that we use to keep the fact finder's attention and to make our point in the most efficacious way possible. But as Peter and Sean say, we've gone from commanding the room to commanding the box. How do we literally think outside the box, Peter? Should we up our production value, like Sean says? Should we consider multiple cameras? What do we do?
I think we absolutely do. And quite frankly, one of the things that jogged my kind of creativeness, so to speak, was that slide you just went through with Tom Cruise. And even just the camera angle, we had, lawyers sitting at the end of a conference room table. It was on the lawyer taking the testimony, and that was it. And quite frankly, maybe we should have backed off on the camera. We should have captured the team that we had there. We should have had another camera where if we did move and go to a flip chart or go to a demonstrative, that we could move and engage. Hard for the panel to sit and listen to talking heads. And quite frankly, I feel like I lost a ton of the taking over the room with the verbal. You can't get all the verbal cues. You can't get all of the nonverbal cues, but we could use a lot more than just sitting at the end of a conference room table and just talking. I think so. If you have the ability, renting cameras is not expensive. Get a couple people, practice, have it up, look at your different variations of angles and what you can do. I think the sky's the limit. When we first started this process, I automatically assumed it was all going to be cool, and that meaning the temperature in the room, we lost some of that human element. And then I thought, well, wait a minute. I watch movies all the time that get your heart rate up and that are fun and engaging, and you can sit there for 2 or 3 hours and feel like you're really moved and involved in the process. Not that we're going to bring in Hollywood producers, but we can go a long way from sitting at the end of a conference room table and having talking heads.
And
go ahead, Sean.
Yeah, it's getting people who want to hear what you have to say. You know, way back when in Brooklyn, I learned from somebody when we were trying narcotics cases, and he was like, in your opening, you got to tell them what you're going to say, and you got to tell it to them, and then you got to tell them what you told them. And you got to keep that theme going, and you've got to keep your case, I think now, as simple as you can to keep people paying attention to what you're saying. And you know, that might sound like it's easy to do, but I think especially with complicated cases, it takes a lot more work to develop those themes beforehand. And to develop the themes that your witnesses, you know, by knowing what your witnesses are going to say, to be ready to present them in a clear manner, because there's nothing to stop the arbitrators right now, or the judge, or even the jury, if they, depending on the situation, from turning off the camera on them and disappearing. They've got the New York Times up. They've got something else going on. They're still there, but they're not paying attention to you. And we need to make sure people pay attention, not just to us, but to what our witnesses are saying.
Rich, I think I know the answer to this, but is it important to have a good camera and a good microphone so that you can be seen and clearly heard?
Before I get to that, I'm going to do my public service as a former Bressler partner and say that we should tell them what the code word is for CLE credit. We're halfway through.
Okay, that's great. All right, the first code word today is unmute.
Well done.
And that's good advice. And it's basic. You can't, no one can hear you unless you unmute. So that's our first CLE code.
So Brad, what are you wanting my judgment on? Forgive me.
Well, I think I'm really asking a rhetorical question. Visual and audio clarity are paramount, right?
Yeah, I mean, look, I can't stand it when I can't hear people clearly. And if there are 10 people on a phone call and you've got 2 with ambient noise and 1 you can't hear and you have to strain to hear, what's worse? So, you know, clarity visually and audio is, to me, 101 and essential.
And Rick, so, you know, you hear us practitioners and regulators talking about, you know, investing in technology, increasing the production value of what we do. And by production, I just mean, you know, being able to be clearly heard and clearly seen. But we have another end to that. We have arbitrators who are, you know, they're paid a per diem, and they are paid for what they do. But a lot of what they do is also a public service, and you know, all of us practitioners appreciate what they do. But they do come to the table with, you know, their own equipment. They're not a member of a law firm often, or another company. They're just sort of relying on their home equipment for these Zoom, you know, hearings or motion practice or whatever. So tell us a little bit about what FINRA is doing on FINRA's end to sort of ensure that technology utilized by the arbitrators is somewhat up to date.
Sure. So Brad, one of the most important things we do with the arbitrators, every single case, we will do a run through well in advance of the actual hearing, the week before, with the whole panel. And we'll make sure that they have the right equipment, that we can hear them, We'll make sure that their backgrounds are appropriate. You'd be amazed. You've seen people who have backgrounds that just aren't right. You don't want to hold a whole bar behind them, for example. Then the other thing we'll do is just walk them through how Zoom works. Not only do you want them to have the right equipment, but you want them not to be afraid of it. And our arbitrators have come such a long way in a short amount of time. We've trained them how to use Zoom. But most importantly, we reassure them that FINRA staff will host the call. We'll do the breakout rooms. We'll put people in executive session, and we'll watch the security of the meeting to make sure no one comes in that shouldn't be there. So the arbitrators, by the end of the walkthrough, feel incredibly comfortable that they understand how it's going to go, that they can focus on the testimony and the witnesses and credibility, because FINRA staff are there for the whole duration to make sure things go smoothly. And Brad, I just want to throw in one more thing. There's a lot of resources that we've provided to arbitrators that are also great for practitioners. So we have 4 training videos on Zoom. I won't go through them. They're on our website. We have a neutral workshop that really was designed for practitioners, where we have Sam Edwards from the PIABA side, and we have Beverly Jo Slaughter from the defense side, and we have an arbitrator walk you through all the tips that we think you should know about, many of the tips, and also provide a little mock Zoom hearing for you to watch. So I encourage you.
I actually watched that video, Rick. I thought it was very well done. And it leads to another point that Sean brought up, and that's how do you deal with exhibits? The video that Rick is referring to, it was interesting because the arbitrator, who's an actual FINRA arbitrator, said that she preferred hard copies, paper copies of exhibits, because she's used to writing notes on the exhibits. She likes the paper copy on Zoom because she can look at the exhibit, but also keep her focus and attention on the question and answer from the attorney and the witness. And then Bev Slaughter turns around and says, well, in our hearings, the arbitrator loved the share screen because they really liked being focused to the specific part of the documents that they needed to pay attention to. And in my hearings, I've heard different things from different arbitrators. I used paper copies for the reason that the FINRA arbitrator said, which is I wanted the attention of the arbitration panel on the testimony and secondarily on the document. But what it really says to me, and I'll open this up for the whole panel, I think first and foremost, you have to have a conversation with your judge or your arbitrators early on as to what they prefer, because you obviously want to meet those preferences. Sean, you talked about exhibits earlier. What are your thoughts?
Well, I actually think even before you're talking to the triers of fact, that you need to talk to your adversary and try and come to an agreement on virtually everything that shouldn't be in dispute. Especially in arbitrations, it's very hard to turn around and say something should be withheld unless it just should be withheld. So come to those agreements, figure out what the joint exhibits are almost. This way people know what's going on there. And this way the two of you can come up with a plan on what you're going to do with triers of fact and how you're going to get the exhibits to them. And then oftentimes, certainly FINRA, I know, its arbitrators are becoming a lot more sophisticated electronically. Rick, you were telling us about how, you no longer have paper applications anymore. Everything's uploaded through the portal. People are used to using the portal. So you can do that. But then Peter, I know, likes to have paper. I've always liked some exhibits in paper. So you can turn around and ship that out both to your witnesses and to those triers of fact.
And I didn't do a bio on me, partly because I feel like the slacker in this group. I've been lead counsel on 60 FINRA arbitrations, so that probably puts me in third place here today. But over the past 17 years in the 60 or so arbitrations that I've handled, I've heard requests from time to time from the arbitrators before COVID, before Zoom, for joint exhibit books. And I actually did that in a JAMS arbitration that I handled back in May. It was a lot of work on the front end, but it paid off dividends when we got to the actual hearing to have that joint exhibit book. Peter, and I know you do exhibits differently from a lot of plaintiffs and claimants attorneys, but is it worth going back to the idea of reconsidering joint exhibit books?
No, the books is the part. Let me just say joint exhibits. Yes, I think joint exhibits, especially on large volumes of docs, it makes all the sense in the world. And I'm not a big fan of the book part because I feel like it gets to be too voluminous, and having the arbitrators ask what notebook again, repeating it just disrupts, to me, it disrupts the flow. But yes, under the joint exhibits.
Rich, what are your thoughts on joint exhibits?
Well, it's not, I won't run into it. I actually have no questions or problems with objections. I can introduce, whatever we'd like on the record or not, but it would hearten me knowing that the venues out there really are meant to vent disputes, that the lawyers could actually work together, do each other a favor and agree on the exhibits, because you don't want in front of the trier of fact a bunch of back and forth about the admissibility of documents.
What's wrong with share screen? Why can't we just use the share screen feature on Zoom? For example, when I share my PowerPoint, what any problems with just relying totally on share screen?
Yeah, so just personally, I am typically lean on the introduction of documents. I mean, the documents are the documents. You need to know the documents, but I try to make the presentation about the witnesses. And in the investigative work, in the depositions I'm doing now, I'm telling my people you should have no exhibits or as few as possible, because to me, the one big real problem with virtual is the juggling of the document, the view, the person, the orientation. I found that to be the most difficult thing to navigate as a regulator interrogating a witness was, and so I'm not a big document fan in this venue, but it is what it is.
And I think too, a lot of times our witnesses, if you're in financial services, tend to be older and tend to have difficulties in dealing with some of the exhibits that are put up on the screen when you share the screen. And you really need to work with them beforehand. I mean, I have a brand new case and I've already got the Zoom call set up for my very first meeting of my financial advisor, because I want to get this person ready from the beginning on dealing with this form should we go to hearing this way.
Yeah.
It's just important. And it also gives me the practice in showing him and sharing the screens and moving around there and showing that I can be nimble or becoming more nimble with working with those documents. If somebody in the Q&A asked about how do you tell whether or not a witness is their body language over Zoom, and I thought that was a good question. And I think part of that goes to, right now we're the lawyers speaking, but you've got to put together your presentation so really you hear and the focus is on the witnesses. And part of that you can do is you can ask the arbitrators to, hide themselves so that you show yourself and them, or yourself and the witness on the screen. You can hide yourself so the only person on the screen is the witness, so everybody can really turn around and focus on that individual. It's just one technique that's out there, as opposed to looking at 4 boxes or 5 boxes or 6 boxes on the screen.
Rick, what are the arbitrators saying to you about how they're receiving exhibits and what this all looks like from their perspective? I'm curious.
So, one, I just want to comment that the arbitrators have been very positive about Zoom in general. We do get a split from the arbitrators about whether they want hard copy documents. Some definitely do. I can tell you that they love joint exhibit books. That I can tell you for sure. If you can do joint exhibit books, you're going to make the panelists incredibly happy. It just makes everyone's life easier. But I think you're going to see some that would be fine with just share screen, or some that only want documents, and some would like both. I do think there's a component of arbitrators who like to take notes on the documents themselves. So there's that.
Peter, what do you think about using exhibits now in this forum?
I'm a big fan of whatever the arbitrators are big fans of. So
exactly.
I think I like paper personally. I like to take notes on the paper. I like to mark up the paper. And if the arbitrator, so to me, we're sending out the documents just as we would for a regular FINRA arbitration. What I think I do differently than a lot of people is I don't hand out those huge books with, I think it's problematic every time you shift to a doc. It's hard for the arbitrators to, what notebook is that? Number 7, and then they have to switch and find. So we do exhibits one at a time. That's how we do the live arbitrations, kind of as a point of logistics. We'll send the boxes with the docs to the arbitrators before we start a session in the morning. I'll take 10 or 15 of those manila folders with the docs in them. We have the arbitrators pull them, and once in a while that doesn't work, but then they all have them in front of them. I also do the share screen. I did not use Elmo. I used kind of the trial director or whatever, the new version of the trial director.
You should tell people what Elmo is, Peter. Nobody knows what it is.
So trial director pops it up on the screen and you can highlight and underline. I love Elmo. I've always used it. Elmo is kind of the old school, when you were in school and you put that transparent paper up on the screen and it would pop up on a projection screen and then you would take notes on it. It's the same thing here. You can put the exhibit down. It electronically transmits the exhibit and it's sitting right. I have one right next to me right here. Now I use it all the time and I take notes. So it allows me to circle, highlight. If the witness says something that's important, I can write it down on the doc. And to me, I didn't do it during my first virtual arbitration. I should have, because it's a way to connect with the arbitrators that I can communicate remotely with my handwriting. So Elmo is it, and they're not expensive. They're less than $1,000, several $100s to use and employ. And it's a nonverbal way to communicate with whoever the trier of fact or the arbitration panel, whoever it is.
And Peter, we, going back to the human element, we are all 5 of us passionate about what we do. We enjoy what we do. And as a person representing a public investor, you often have clients as claimants who are unhappy, to say the least, and some can be emotionally devastated from their financial losses. Representing the financial services company, we often have a financial advisor who is perhaps upset because it's the first time they've ever had a complaint in their life. Emotions can run high in these hearings. Emotions can run high in courtrooms. And us lawyers, we're not immune to that because we're passionate about what we do, because we are zealous advocates for our clients. Sometimes our personalities can be, let's say, on the warmer side. And I know you're a practitioner that can be, a big personality in the room, let's put it that way. And you feel like that's effective for you. What has Zoom done? How has that affected, your ability to come across as the passionate advocate that you are?
Thanks. I think you made that description generous. Thank you. I personally think, and I was warned about this, but I made a bunch of calls before we did our first one, but I think the volume's turned up over Zoom, that your face is right in the camera. You're right on top of people. So I think the litigator has to be extremely cognizant of how, if you use cadence, you use pace, you use volume as a tool, slow, fast. Be careful, because I think it's magnified on Zoom. I knew that going in. I still think that the volume might have been a little too much and probably should have turned it down. But then I was worried about how to highlight, how to punctuate, how to, the nonverbal cues. So I think you just have to be cognizant. I think the volume, pace and how loud is higher. And I think it's the same thing on the slower and the, you have to be careful, because I think it's magnified on both ends of the spectrum. So I think that's one of the huge, and in person, sometimes we all talk over each other. On Zoom, that doesn't work at all, because you can only hear one at a time. And so you know, to that effect, you have to be cognizant of the difference between two people talking or talking over each other versus on Zoom, which does not work at all. Doesn't work well in live either, but certainly doesn't work on Zoom.
Yeah, and while we're on that, we're having a little technical issue there. Let's talk about that, because this is a best practice that you should immediately implement. And it's one you should do when you do live hearings. But as Peter has said, as Rich has said, this is critically important over a Zoom hearing. You have to set the tone early for fair and orderly communication. And all of the arbitrators that are on this webinar know that we lawyers like to talk, and we often like to have the last word. You're going to have to change that for Zoom. You can't talk over each other, where, just like Peter says, whereas you might be able to do that somewhat in a live hearing, you can't do it in a Zoom hearing. The other thing you can't do is you can't just filibuster. One thing I started doing probably the third day into my first Zoom hearing was when I needed to object to a question, or when I needed to bring up perhaps a motion that had been tabled for later, I would politely interrupt. I would raise my hand and not speak until the chair recognized me. And then when I was recognized, I would say, you know, for example, I've got an objection. Give me just 20 seconds to explain it. Or, Madam Chair, this is going to the heart of our motion in limine that we tabled. And so now is the time to address it. I'd ask the panel for 3 minutes so that I can address that. When you do it that way, when you announce the length of how long you're going to talk, you're going to immediately put someone at ease. If I just start talking, Peter's going to think, here he goes again with his closing argument. So that's a good tip I think you should use. Also, set the tone early for distractions. Behave just as you would in an in-person hearing. I had a lengthy motion hearing back in July where we were all there by Zoom. And one of the participants, and I'm not kidding, was on a laptop and probably, like Goldilocks, sat in every chair in his house at some point or another during the 4 hours of the hearing. And at some point is in the kitchen, you know, pouring a glass of tea. And you can't do that over Zoom. It's, you know, it's just something about the medium. In a hearing room or even in a courtroom, you can get up and get a glass of water, and it really doesn't bother anybody. But on Zoom, it is a huge distraction if you are doing anything other than paying attention to your screen.
I would encourage people to take frequent breaks as a remedy. I mean, even just this call, let's say it went for another 2 hours. Let's say I had a 2 hour, not an hour and a half. I'm sitting in like basically a 2x2 box here, and it's fine. But, you know, as you say, at a hearing, there's natural movement around the room and so on and so forth, and everybody's in that same boat. So, you know, I know that when we were doing the remote depositions, investigative depositions, I would let people take a break as frequently as they wanted, and it was usually once an hour.
Yeah, the other thing too there is if you watch people and they get up and disappear, you know, everybody's attention is, where did so-and-so go? As opposed to listening to the witness, or as opposed to listening to the arbitrators, or they start getting distracted by what's going on, you know, behind you. Like, is there a dog in that yard? Is there a fan going on? How often is that curtain going to wave back and forth? And these are all things you've got to think about when you're in your director or producer role in presenting the case.
Rick, we've had a number of questions. I was just glancing at the Q&A, and we've had a number of questions from the arbitrators who have asked, how do we get hard copies of the exhibit books, because FINRA is paperless? Isn't it okay if, for example, Peter and I agree that we will FedEx each arbitrator a copy of the joint exhibit book?
Yeah, Brad, that's fine. And also, if the arbitrators prefer, we can have you send it to our Boca office, and we have staff in Boca coming in every day. and shipping things out. So if the arbitrator's not comfortable giving out their address, we can get it to Boca and ship it back out.
What about, let's talk about something I think we've all experienced, and that's Zoom fatigue. You know, there is something about staring at a screen for 8 or 9 hours a day that is more taxing than being there in person, where you can avert your gaze. You could, you know, it just is. So, you know, Sean, Peter, Rich, Rick, anybody chime in here. What are we going to have to alter about the proceedings to address this fatigue that arises from staring at a screen all day?
Well, the first thing I did, like when we started this even, is I turned off the self view of my camera. So I can't see myself right now, because I find that when I can see myself, I get ultra critical of how I look. I don't like how I look. Okay. And I think all of us have that view, like, do I really look okay?
Oh boy.
And so, think about it, right? So
you're hysterical, Sean.
Eliminate that. All right. And that, I think, goes a long way to helping it here. Because, you know, if you're in person in front of arbitrators, you can't see yourself. Okay. So you can't judge yourself. You might make mistakes, and I make a lot of them, but you're not hypercritical that way. And I find it's a lot easier and relaxing when I do that. That's my point of view.
What about, you know, we've talked about the limitations of Zoom, you know, being able to command the room versus commanding the box, 3D versus 2D. Let's give us practitioners and FINRA a little hope, and the arbitrators. What are some of the possibilities that have been opened up by Zoom? And Rich, I think you mentioned one about, you know, possibly having either day in the life videos or being able to, you know, work on opening and closing videos. Tell us a little more about that. I think you're on mute there, Rich.
Sorry. Yep. So, you know, in talking, frankly, as part of the preparation and talking through this seminar, one of the things that occurred to me, because we were talking about production, Sean, you know, producer, director, why not have, I mean, in the opening, it'd be more difficult. You're obviously limited to the evidence, whatever venue you choose. And in the closing, you get, you know, obviously to make your arguments. Why not have a film, 2 to 3 minutes? Think of the films they run before the Republican and Democrat national conventions. It tells a story. It orients the viewer. It's like what's in the movies called the acclamation shot that can set the table for you to go ahead and do your presentation. I think it, you know, it's a great, and you're not limited by whatever the technology is, by the, you know, what's in the room. You can make your own little thing and, you know, obviously exchange with your adversary and present it at the hearing.
I had a mediation probably, I don't remember, 6 or 7 years ago, but it was a lawyer who had probably 8 or 9 claimants in one case. And during the mediation, most of these people were not in a position to travel to the mediation location. And so what he did was, he actually went and hired a videographer to go to, you know, where these claimants lived and just shoot a short 2, 3, 4 minute video, just sort of a, here's who these people are, you know, as you know, value this case and decide, you know, what's going to be the disposition of it. And it was very helpful to me and the mediator to see that. And so, you know, Peter, is that something that sparks any interest in you? What do you think about the taking advantage of the flexibility of Zoom?
I think that's a great idea. I think every participant, and this is what's so great about Bressler putting this on today, the folks on the opposite end of the arbitrators, the judges, the juries, whatever, that are going to be hearing these, is I think we need to look at also what the arbitrator or the jury, their judge is seeing. And I think that video is a great idea, but I think one of the challenges is, I know that Bressler's got tremendous resources. I do, in the remote settings that we're doing. I have huge monitors, multiple monitors, dedicated monitors for witnesses or panel, dedicated monitors for the docs. And I know we have a lot of folks on the other end trying to do this all on one screen. So when a document comes up on the screen, either the boxes of the witness or the attorneys become so small, or they're gone altogether. I think that's a huge problem. And I'd like everybody to kind of, when we start these Zoom arbitrations or trials, to kind of jointly think about some of the verbal and nonverbal cues, whether that be videos like you mentioned, but let's change or shift the paradigm of what we've been doing on these conference call Zooms and think about new and creative ways to do this. And I was watching, excuse my analogy here for a minute, but I was watching this. I love the Late Late Show with James Corden. And the model for these late shows have always been the interviewer, the person sitting in the chair, you got the band off to the side. That's been the model going back to Johnny Carson 30 or 40 years. If you haven't seen James Corden's carpool karaoke, where you have Paul McCartney, Adele, the Migos, he brings these bands and puts them in his car and they play music and he interviews them while they're in the car. How genius is that? And it's intimate. Everyone can understand, sitting in the car with everybody else. He's exploded all over social media. And there he is thinking outside the box. It's not your typical interviewee style. And I think that's a great way to look at what we do here. It doesn't have to be a box. It doesn't have to be a face, but we need the arbitrators to help us look at this, and judges look at this and take some cues from us. And then we take cues from you all about setting up more resources for the arbitrators to be able to take advantage of all the tools. One screen I think takes away and handcuffs and restricts us and the parties, the defendants, the plaintiffs from doing our job. So I think all of us as participants in the process that's going to go on for a while can help shift the paradigm of how we're looking at this and really change it. And the video idea that Richard came up with is great, but I'm confident there's also other ways that we can all come up with a better experience for everybody that will help the fatigue component, will keep everyone engaged, and will give us a better product for everybody, and the defendants, the plaintiffs, and everybody, that we can put together a better product, because I do think we're going to be doing this for a while.
And Rick, keying off of what Peter just said, that, he thinks we're going to be doing this for a while, and we may have covered this earlier, but what has been the general reception of the arbitrator pool just in general to Zoom?
Brad, it has been very, very positive. The arbitrators like working with Zoom. They feel like they don't feel like they're losing that much. And I think that, I think I've only seen one comment where they weren't happy about how the exhibits were done. Speaking of exhibits, otherwise it's been pretty much uniformly favorable. But Brad, I just wanted to throw in one more thing that I meant to mention earlier, and I don't want this to end without saying it. And that is, I told you how we will do these walkthroughs for arbitrators, but we'll also do those walkthroughs with practitioners. So if it's your first Zoom hearing, or even if it's your fifth and you want to have it done in advance, we will meet with you and your team. And if you can get the other side to agree, we'll do it with the whole group, including the arbitrators. So I want to make sure everyone knows about that.
Rick, didn't you tell us that you're starting to do the initial pre-hearing conferences via Zoom as well?
Right. So we haven't done that as a matter of course yet. We have so much staff working on sitting through the actual hearings. But if the parties agree, we will do that for you. The initial pre-hearings, dispositive motions, discovery conferences. We're not doing it as a matter of course yet, but once we start winding down the Zoom hearings, the numbers we're doing today, I think it's a natural future course of action for us to do the IPHCs, for example, the initial pre-hearing conferences by Zoom. It'll give you all a chance to see your arbitrators in advance, get them to know you, et cetera.
Yeah. And then
it's just real quickly, it's time for the second CLE code, and this one is Blur's Day. if you have to ask what day it is, it's probably Blur's Day. It's one of the Oxford English Dictionary's 2020 word of the year. So Blur's Day.
Makes sense. I guess the only thing I'll add is, as a regulator, looking at the process working, and we do look at the FINRA dispute resolution process as a big part of the system working for investors and firms to properly have an opportunity to present their side of the case. My only comfort is this phenomenon is delivering pain equally on both sides of the V. And so, getting back to the survey that Rick, you mentioned, it is a little disheartening for me to hear that somebody is, I'll say, not meaningfully looking at the data and coming up with an analysis that actually corresponds with the win rates. Because from my perspective, I want people to have confidence in your enterprise, and I think they should. So I do appreciate you pointing out that it appears to be operating fairly for the litigants.
And Rich, there was a question or comment that I saw that I wanted to address on that very point. Our stats on our website today do count. They do count those dismissals, whether it's 6-year eligibility or any of the others, as customer losses. All I was saying is, when you do apples to apples, Zoom versus in person, taking those dispositive motions out, they're very similar results.
Look, we've got a couple questions too about cost with some of the issues that we're hitting here, and I think FINRA and the parties are saving a ton of money because we don't have to stay in hotels. There's not a lot of traveling. And I mean, if we're talking about the cost of a couple of monitors and having some IT people present between FINRA or the parties to help the arbitrators or the, some cases, smaller state courts, whatever, walk through this, I think most parties are willing to put the cost forward, so the experience for everybody involved is a better experience. We all want to communicate better, more thoroughly and creatively. And I think the parties are more than willing to shoulder some of that technology. If I'm let me just say one more thing. I know that like Bressler shop and in our shop work collaboratively for in trial, where we put up all kinds of monitors and screens, and each, just like we're in federal court, the witness has a monitor, every arbitrator has a monitor. And we can do the exact same thing here if we all work collectively together. And I think the experience for everybody involved is going to be better if we keep thinking outside the box. And the parties should be able to, the cost of these arbitrations should be decreasing because of the lack of travel.
And that obviously makes me happy because anything that makes the forum more accessible for more people with legitimate claims, from my vantage point, that's a plus.
Rick, go ahead, Sean.
Yeah, and if you think about what Peter said, a good camera and a mic, you can pick them up for $100. You can pick up a couple of monitors for a couple $100. I mean, if I have no problem having an agreement with you, Peter, on a case we're going forward with, to make sure that every arbitrator has 2 monitors so that we can put the case together that we both want to show these triers of fact. I just think that's an important conversation you have to have with your adversary. And quite frankly, if the other side doesn't want to have two screens there for whatever reason, I'm going to bring that up to the panel and suggest to the panel they let us do it anyways, and tell them that I'll share that, stuff with my adversary. I just think that it's important for us to use these tools so we can present our case. And on that end, I think it's also important to make sure those tools aren't just provided to the arbitrators, but to the witnesses out there. And that requires us to work together.
Good point. Because a lot of the witnesses are remote. I didn't think that through in the very beginning about just how complicated getting the exhibits to where the opposing counsel is. Maybe there's even in-house counsel or the corporate rep. Then you have the witness in a different location. You have 3 arbitrators in a different location. This, from the practitioner side, that's a lot of moving parts with a lot of documents going in different places. And but Sean, you're totally right with the witnesses being in different places, because I forgot about that. And I think the case that we did, we had, let's see, 360. I think we had almost 12 different locations at any one time with the 3 arbitrators, opposing counsel, local counsel, witnesses. It was a lot. There was a lot of moving parts.
So we have just a few minutes left. And like I said earlier, there's going to be a PowerPoint available, but I hope that what we've conveyed to everybody is this is, it's a new medium, and it's going to take thinking through how you do this. You're going to have to be familiar with the technology. You're going to have to learn Zoom. You're going to have to be familiar with your equipment, and you need good equipment because, and lighting is important. For example, I, stumbled through this trying to do this myself. And finally, it was my 2 daughters who, they know how to shoot videos. One's actually a videographer for her high school. And they're like, Dad, you need some help. And so I actually reached out to a local film and television producer and director here in Birmingham. And really with, I would say, less than, $1,000 worth of equipment and good lighting, he was able to, hopefully make what I think is a good looking product right here on the screen. So invest the time and effort into it. Think through the issues that you were going to face. And more than anything, feel free to reach out to any of us who were on this call today. We'd be glad to talk with you about more detailed things. There's been a lot of very good questions that have been submitted through the Q&A, and we will try our best. We don't have time now, but we'll try to figure out a way to answer these and follow up with the registrants here today. So with a couple of minutes left, I'm gonna allow each person any parting words if they have any. And Rick, we'll start with you.
Sure. We're going to do what we did with the portal and look to continually improve our Zoom process. So please, practitioners, arbitrators, let us know what we can do better. Let us know where the pain points are. We want to improve this as we move forward. So don't hesitate to give us some feedback.
Peter?
I think the most important thing I can think of is that we all work collaboratively together. I keep using the term that we're trying to solve problems that people may not even know exist, and that there's a lot of experience from FINRA. FINRA has done a great job of organizing a lot of the advice and communication with the parties and the arbitrators. But I think we have really sophisticated advocates on both sides of the table that have very sophisticated IT departments. And that I think a couple of pre-calls with the parties where everyone provides input, they think collaboratively together about how to provide the best production. And both sides, arbitrators listen to the advocates. I think advocates listen to the arbitrators and know that FINRA does a wonderful job of allowing us to shape and sculpt how this process works. And if we all work together, we can have a better product.
Rich?
Thanks, Brad. Pleasure to be with all of you. It actually was, I thought, a lot of fun, and I learned a lot running up to the presentation. I'm an optimist. I think that a year from now, the equation we're looking at is going to be flipped on its head. It's going to be fractional, virtual, majority in person. Right now, it's majority, virtual, fractional, in person. But I'm heartened by the steps that are being taken. Similar steps, by the way, are available through the courts. I know New Jersey, for example, I'm going to thank Jeff Pollack for sending me this note. New Jersey courts are opening for trials May 17. So, the end is, over the horizon where I don't know. And then last, real quickly, if I can pander to half of our audience and say, God bless on International Day of the Woman. And I'll give you a little tidbit to encourage you that the women are really perhaps the sensible class. I've worked on probably 300 fact patterns in 18 months at the Bureau, and exactly 0 involved a bad actor who was a woman. So I'm not sure how often that gets talked about in regulation, but if you have a suspicion and you have a man and a woman who are possibly to blame, take a hard look at the man.
Sean, the orchestral music is playing, so.
Yeah, and so I think the most important thing is don't be afraid to be yourself when you're doing this. And think back about what has worked in your whole career and figure out how to continue to do that. And I think if you do that, and if you are true to yourself, panel will see, arbitrators, judges, juries, they'll see that you believe in your case, and hopefully the sincerity will come through and you'll present the case your clients want you to present.
Well, I want to wrap it up. I want to thank all of the 400 plus registrants and audience members who have listened to us today. I see a lot of nice comments pouring through. We really appreciate that. I think you can tell we're passionate about what we do, and we like to do it, and we like to constantly improve. Rick, thank you so much for being here today. Great face for FINRA, and we just really appreciate it, and I know the audience appreciates it. Peter, always a pleasure to hear your insights as a leading practitioner. Thank you for being here today. Rich, so good to see you. Nice to know you're a cop on the beat now. Thank you for your participation today. I do want to thank Rebecca Johnson, who is our marketing coordinator, who has tirelessly worked to put this webinar together. Also, thank you to Shannon Lazarus, who works, is actually our director of marketing and business development. And lastly, I want to thank Alex Kiker. Alex is the local Emmy Award-winning television film producer and director that helped me out of my pit of sorrow when I was struggling with some equipment. So thanks to all. That's the end of the presentation. We are considering a short survey, no more than 3 or 4 questions to the registrants. So be on the lookout for that. Thank you. I hope everyone has a nice rest of the day and rest of the week. Thank you.
Thank you, guys.
Bye-bye.
Thanks, Brad.